Well, welcome everyone. This meeting of the Florida Advisory Committee to the U.S. Commission on Civil Rights shall come to order. Today is Monday, March 28th at 2 p.m. I would like to invite Liliana Schiller, the support specialist for the Florida Advisory Committee, to assist with roll call. Committee members, if you are joining by phone, please press *6 to unmute yourself and *6 to place yourself back on mute until I call on you during the Q&A. Liliana?
Thank you, Chair Smith. Okay, so committee member Warren Belmar. Great. Committee member Bradford Brown.
Present.
Committee member Thomas Newcomb Hyde.
This is Warren Belmar. Did you hear me being present?
Yes, we did, Warren. Thank you.
Okay, thank you.
Committee member Newcomb Hyde, are you able to?
Present.
Oh, wonderful. Thank you. Committee member Charlene Taylor Hill.
Present.
Committee member Linda Kidwell.
Present.
And I, Nadine Smith, am present. Liliana, did we lose you? I think we possibly did. All right, well, let's keep going. Michael Morley.
Someone has to
Present.
unmute.
Thank you. Brandon Wolf. I did not.
So Brandon Wolf will be unable to join at this time. Thanks, Chair Smith.
Okay, you want to continue?
Sure. Victor Romano.
Present.
Thank you. And Tufik Zakaria. And I do not see that Tufik has joined. All right, Chair Smith, I will turn it back to you at this time. And before I do that, we are going to turn the mute function back on. So one moment, Chair Smith, and I will send you the request to unmute. And you may proceed at this time. Thank you.
All right, thank you. Also present are commission staff, and there may be members of the public who have joined in a listen-only capacity until I invite them to share comments during the public comment period. American Sign Language and closed captions are available for today's briefing. To view closed captions, click the three dots located in the bottom right-hand corner of your screen, and then click the multimedia viewer. The U.S. Commission on Civil Rights is an independent, bipartisan agency of the federal government charged with studying discrimination or denial of equal protection of the law because of race, color, religion, sex, age, disability, or national origin, or in the administration of justice. In each of the 50 states and the District of Columbia, an advisory committee to the commission has been established, and they are made up of responsible persons who serve without compensation to advise the commission on relevant information concerning their respective states. Our purpose today is to hear testimony regarding voting rights in Florida. If speakers begin to veer away from the civil rights questions at hand to discuss possibly important but unrelated topics, I will interrupt and ask them to refrain from doing so. Today's meeting is part of a series of meetings the committee is hosting on this topic. All meeting information is available in the Federal Register. Based on the information collected through testimony, our committee will draft a report to the U.S. Commission on Civil Rights that will include findings and recommendations. The commission will then forward those recommendations to the appropriate federal, state, and local entities. I will present the ground rules for today's meeting. This is a public meeting, open to the media and the general public. This meeting is being recorded for the public record. We have scheduled panelists who will be making presentations within the limited time available. The time allotted for each presentation must be strictly adhered to. This will include a presentation by each invited panelist of up to 10 to 12 minutes. After all the panelists have concluded their statements, committee members will engage them in questions and answers. The rules for the committee Q&A portion of the discussion are as follows. The Q&A session is reserved for committee members only. The committee may ask questions of the entire panel or individual members of the panel after all panelists have had the opportunity to provide their prepared statements. Committee members must be recognized by the chair before asking any question of the participants. Once recognized by the chair, it will take a moment for the recognized member to be unmuted within the WebEx platform, and they will then need to unmute themselves in order to speak. This can take a few moments to coordinate, and we ask for your patience. In addition, because of the large number of members and the short amount of time, each committee member will be limited to one question. The chair may return to ask if committee members have follow-up questions as time allows. To accommodate persons who are not on the agenda but wish to make statements, a public comment session will commence once the committee Q&A period concludes. At the appropriate time, when I indicate to do so, anyone wishing to make a statement should press *3 on their phone or use the raise hand function on their web browser to request that their line be unmuted. They will then have the opportunity to unmute themselves in order to speak. In order to ensure that all aspects of the issues are represented, knowledgeable persons with a wide variety of experiences and viewpoints have been invited to share information with us. Though some of the statements made today may be controversial, we will want to ensure that all guests do not defame or degrade any person or any organization. As the chair, I reserve the privilege to cut short any statements that defame, degrade, or do not pertain to the issue at hand. Any person or any organization that feels defamed or degraded by statements made in these proceedings may provide a public response during the open comment period. Alternately, such persons or organizations can file written statements for inclusion in the proceedings. I urge all persons making presentations to be judicious in their statements and keep the civil rights topic at hand. The Advisory Committee appreciates the willingness of all participants to share their views and experiences with this committee. Before we begin hearing from our panelists, I would like to thank Commissioner Debo Adegbole, who will need to unmute your line once unmuted by WebEx. Please begin when you are ready.
Good afternoon, Madam Chair. It's so good to be with you. And thank you once again to the Florida State Advisory Committee for your focus and efforts in the area of voting rights. Some of you may know that the U.S. Civil Rights Commission has focused on voting perhaps more than any other topic in the history of the U.S. Commission on Civil Rights since it was created in 1957 as part of the Civil Rights Act. And based on recent experience and the very good work of this body, I think that you are a state advisory committee that is working in parallel to focus on this very important civil rights issue from your state perspective with equal vigor and attention. I had the great pleasure right before life sort of shut down in the country during the COVID-19 pandemic to join the State Advisory Committee in Florida for your February 27, 2020 briefing. And we're very grateful for the work that you did in connection with that report, including the series of findings that you shared and provided to the people of Florida and to the U.S. Civil Rights Commission about your findings after having taken testimony the last time around. You covered a broad range of issues, and we don't have to review them all, but there were lots of access issues about same-day voting and election day access as voter registration options. There were additional things that you spoke to about early voting and vote by mail, making the polls open at times that could provide greater access. There were some observations about impediments to formerly incarcerated persons who were seeking to vote, and additionally, with respect to having a fail-safe paper option, should there be machine malfunctions and the like. The work on the day that I joined you and the testimony was detailed and important. The synthesis you put together was valuable, I think, to the people of the state of Florida and certainly to the United States Civil Rights Commission. And I would just like to commend you and thank all the members of the State Advisory Committee and the witnesses whom we will hear from today for your commitment to these issues and for trying to ensure that there is access to all of those who would seek to have their votes cast and counted in Florida. Thank you very much for the opportunity to address you today. Thanks for your good work, and we look forward to your report at the conclusion of your study.
Thank you so much for joining us today, Commissioner Adegbile. At this time, I would like to invite our first panelist to begin. As a reminder, committee Q&A will not commence until after we've heard from all 4 of our speakers today. Professor Daniel Smith, will you begin your remarks?
Thank you, Chair Smith and members of the Florida Advisory Committee to the UCCR. My name is Daniel Smith. I'm professor and chair, Department of Political Science at the University of Florida. For nearly 30 years, I've conducted research on electoral politics in the American states, focusing on the effect of political institutions on political behavior. I have written extensively on election administration in the American states, including the effects of changes of election laws and rules on voter participation and turnout in Florida. And I have served as an expert in dozens of election-related lawsuits in several states, hired by both plaintiffs and defendants, including in the state of Florida. Free and fair elections are fundamental to democratic politics. Universal suffrage, at a minimum, necessitates that every eligible citizen has the right to register to vote and to cast a secret ballot. Unfortunately, having the right to vote does not guarantee that all those who are eligible to cast a ballot have an equal opportunity to do so. Whether a voter has the ability to take advantage of the franchise depends, in part, on the cost of voting. As traditionally conceptualized, the cost of voting comes in the form of time, information gathering, transportation, health considerations, among other potential barriers. An individual's ability to overcome the cost of voting, one can think of this as the ability to participate in the electoral process, depends on his or her personal circumstances. As such, changes to the election administration landscape, even seemingly minor tweaks to the rules of the game, can limit a person's ability to register to vote and to cast a valid ballot. Immediately after the November 3rd, 2020 general election, Governor Ron DeSantis praised Florida's electoral process, saying, "People are actually looking at Florida and asking the question, why can't the states be more like Florida? The way Florida did it, I think, inspires confidence. I think that's how elections should be run." The state's 67 Supervisor of Elections also heralded the success of the 2020 general election. Pasco County Republican Supervisor Brian Corley, a former chair of the Florida Supervisors of Election Association, said he was beyond highly confident that the results of the 2020 election were correct. And Miami-Dade Supervisor Christina White said that the integrity of the election was upheld throughout the entire process. Voting was made accessible and convenient to our voters. The results were tabulated accurately, reported to the state on time, and voters had a pleasant experience. However, less than 6 months later, on April 29th, 2021, on a party line vote, the Republican-controlled Florida legislature adopted Senate Bill 90, an omnibus piece of legislation that targeted numerous provisions of the Florida Code of Elections. During a live closed-door morning broadcast on Fox and Friends a week later, Governor DeSantis signed the bill into law, stating, "Me signing this bill says, Florida, your vote counts. Your vote is going to be cast with integrity and transparency, and this is a great place for democracy." Voting rights groups were not so sanguine. The League of Women Voters, the Florida State Conference of the NAACP, Disability Rights Florida, Common Cause, Florida Rising Together, Unidos US, and a host of other voting rights organizations filed 4 separate lawsuits in federal court, suing the Florida Secretary of State Laurel Lee and the state's 67 Supervisors of Elections. Plaintiffs argued in federal court that the law imposed severe burdens on the right to vote for people of color and individuals with disabilities, challenging specific provisions of SB 90. Section 28, the Dropbox provision, Section 29, the line relief provision, Section 24, the vote by mail application provision, and the vote by mail request identification provision, and Section 7, the registration disclaimer provision and the registration delivery provision. The adoption of SB 90 came on the heels of a presidential election that was not only heralded by Governor DeSantis and the SOEs, but also witnessed record vote by mail turnout in the midst of a pandemic, including an unprecedented surge in minority voters requesting and casting mail ballots and a record use of 24/7 drop boxes to return their vote by mail ballots. I had the honor of serving as an expert for 2 sets of plaintiffs in the SB 90 litigation. I wrote 3 expert reports totaling more than 200 pages and provided extensive testimony on the stand in early February. My expert analysis, which analyzed documents, emails, text messages, depositions, and raw data files produced in discovery by the Florida Division of Elections and the 67 Supervisors of Elections, revealed that SB 90 harmed the ability of all voters, but particularly Black and Hispanic voters, as well as individuals with disabilities, to register to vote and cast a valid ballot in Florida. My analysis found that roughly 31% of all vote by mail ballots returned in the 2020 general election, some 1.5 million out of the 4.85 million VBM ballots cast, were deposited in secure Dropbox locations maintained by SOEs. Because of SB 90's restrictions placed on Dropboxes in the 2020 general election, voters will have fewer locations, fewer days, and fewer hours to return their vote by mail ballots compared to the 2020 general election. At least 65 24/7 drop boxes available to voters during the 2020 election will be eliminated in the 2022 midterm election, according to the SOEs themselves. At least 1/3 of the 67 counties will cut available outdoor drop boxes in 2022 compared to 2020. And 60% of counties that previously offered 24/7 drop boxes will eliminate them entirely. My analysis identified at least 57 drop boxes that were available across counties and that accounted for over 11,000 hours of drop box availability that will be eliminated under SB 90. My analysis reveals that these restrictions on VBM drop box locations, days and hours, increases the cost of voting for all Floridians, but particularly for Black and Hispanic voters. Most notably, because of a lack of access, voters casting vote by mail ballots will be forced to deliver their mails by post, which increases the chances of them being rejected because they arrive after Election Day deadline, as well as deprive voters of valuable time in case they need to cure a mismatch or missing signature on the return ballot envelope. I also offered evidence that SB 90 restricts the ability of voters to request a vote by mail ballot by requiring certain forms of identification. Drawing on data provided during discovery from the Florida Division of Elections, around the time SB 90 passed, more than 681,000 voters did not have a valid ID number on file to be able to request a vote by mail ballot. Under SB 90, voters with neither a driver's license, state ID, or social security number on file cannot request a vote by mail ballot at all. There are no exceptions. I found that of those who successfully registered to vote in Florida in 2016, 2018, and 2020, Black and Hispanic voters were more than likely than white voters not to have a driver's license or a social security number on file with their supervisor of election. In addition, more than 3 million registered voters in Florida lack either a driver's license number or the last 4 digits of their social security number on file. And as Secretary of State Lee has noted, when applying for a VBM ballot, a voter could not be expected to know whether they provided a driver's license number or a social security number at the time of registration, making it a crapshoot when they try to request a vote by mail ballot. Furthermore, I provided evidence that voters of color were more likely to face longer lines at the polls and analyzed data turned over by the Division of Elections that conclusively showed that eligible Black and Hispanic citizens were 5 times more likely to register with a third-party voter registration organization, a 3PVRO, than white individuals. It is important to note that SB 90's challenge provisions imposed on Florida voters serve no legitimate state interest. As the supervisors themselves have stressed, there was no evidence of systematic fraud in the 2020 general election. Rather, SB 90 can rightly be understood as a discriminatory backlash by the Florida legislature to target with precision voters of color who shifted towards voting by mail in the 2020 general election. A recent study, Cost of Voting in the American States, provides an index of both the opportunities and restrictions on the franchise in each state. For example, registration deadlines, registration drive restrictions, early voting and voter ID laws, and poll hours. Prior to the passage of SB 90, only 10 states had worse cost of voting index scores than Florida. The restrictions put in place by SB 90 will likely move Florida, which has a sordid history of discriminatory barriers to voting dating back to the days of Reconstruction, further down the list of states with the highest barriers to the franchise. Federal District Judge Mark Walker has yet to issue a decision on the SB 90 case, in large part because he awaits the unfinished business of the Florida legislature and Governor DeSantis following the 2022 legislative session. Specifically, Judge Walker has said he is awaiting the governor to sign SB 524, which as of this morning still has not been transmitted from the legislature to the governor's desk. Like clockwork, this spring it was time once again for the state legislature to tighten the screws on the ability of eligible citizens in Florida to register to vote and cast a valid ballot. The latest legislation, SB 524, places additional restrictions on voting in elections in the Sunshine State. Akin to its 48-page SB 90 predecessor, SB 524 is a 47-page omnibus bill entitled An Act Related to Election Administration. SB 524 creates a costly new and wholly duplicative Office of Election Crimes and Security. Millions of dollars are dedicated to forensic and audit systems already dedicated and required by SOEs at the local level. The new office's unsworn officers might possibly subvert the efforts of sworn officers who are currently tasked with making sure our elections are safe and secure. With language at times evoking the Ministry of Truth in George Orwell's dystopian novel 1984, Florida's Office of Election Crimes and Security has the potential to chill voter participation. The annual reporting requirements for the new office lack transparency and could lead to unsubstantiated, frivolous, or even fraudulent claims about voter fraud, further dampening confidence in our election system and hampering the efficacy of SOEs to carry out election securely. SB 524 raises the cap on fines from $1,000 to $50,000 for third-party voter registration organizations registering eligible voters for the rolls. It ramps up minor election-related misdemeanors that sometimes accidentally happen during voter registration drives to felonies. According to testimony in the SB 90 litigation from Divisions of Election Director Maria Matthews, prior to SB 90, Florida had in place processes to identify voters who die or move to or from Florida. But SB 524 increases those requirements to purge voters. SB 524 further criminalizes the good faith efforts of individuals helping their unrelated household members, neighbors, and fellow parishioners, and others who might need assistance returning their vote by mail ballots. What was once lauded as civic engagement may now result in Good Samaritans losing their civil rights, as any person who distributes, orders, requests, collects, delivers, or otherwise physically possesses more than 2 vote-by-mail ballots per election, in addition to his or her own ballot, or the ballot belonging to an immediate family member, commits a felony misdemeanor of the 3rd degree. Felony of the 3rd degree. Potential fines and criminal violations will only further chill the efforts of voting and civil rights groups, as well as political parties, from reaching out to eligible younger voters, voter transplants, and naturalized citizens. Not coincidentally, communities of color depend heavily on civic groups when registering to vote, as well as receiving assistance when returning VBMs. Finally, SB 524 amps up voter list maintenance, another unfunded mandate placed on SOEs who did not request changes to what is already a well-functioning system. Regular statewide list maintenance has been going on in Florida for 2 decades. Registered voters who have not made a change to the registration and have not voted in the previous 3 years may be purged from the rolls, and SOEs must now conduct an annual list maintenance program rather than only having to do them in odd number of years. What makes these requirements even more galling is that only 2 years ago, Florida joined the Interstate Nonprofit Compact, the Electronic Registration Information Center, or ERIC, to identify voters who have moved in and out of the state. When done incorrectly, list maintenance removes eligible voters from the rolls, a topic on which I'm well too aware, as I was the expert for the plaintiffs in the successful 2012 litigation, Arcia v. Detzner. That lawsuit challenged the Scott administration's bungled effort to identify what it claimed were more than 180,000 potential non-citizens on the voter rolls, and forcing SOEs to purge 2,625 registered voters from their voter list who were wrongly tagged by the Division of Elections. I conclude by asking a simple question. Why is SB 524, or for that matter, SB 90, necessary? Florida elections were safe and secure prior to SB 90 and SB 524. Our frontline experts, supervisors of elections and their staff, Republicans and Democrats alike, did not call for either bill. SB 524, like SB 90 before it, hampers the good faith efforts of SOEs, but also voting rights groups who assist in providing access to the polls that is essential to ensure that voting is a right more than in name only. The recent legislation undermines confidence in elections in Florida and makes voting and elections less free, fair, and accessible for all Floridians, but particularly for racial and ethnic minorities and individuals with disabilities. Thank you again, Chair Smith, for inviting me to participate and provide testimony on this vital issue.
So one moment, Chair Smith, I'm going to send you the request to unmute while you move on to the next panelist. And Amir, I will be doing the same for you at this time as well.
All right, wonderful. And I will go ahead and invite Amir Badat, manager for the Voting Rights Defender, to speak to the panel.
Thank you, Chair Smith. Good afternoon to you and to the other members of the committee. My name is Amir Badat, and I am the Voting Special Counsel and Manager of the Voting Rights Defender and Prepared to Vote projects at the NAACP Legal Defense and Educational Fund, or LDF. Thank you for having me here today to discuss this extremely important topic ahead of the 2022 midterm elections. We're in the midst of one of the most aggressive and concerted efforts to undermine voting rights in this country in more than a generation. Over the past 2 years since the 2020 general election, hundreds of bills have been proposed in state legislatures across the country to restrict access to the ballot box for all Americans, particularly voters of color and voters with disabilities. Dozens of these bills have become law, including in Florida. In my remarks today, I'll discuss some takeaways from the 2020 general election, and then I will hone in on the two pieces of legislation that Professor Smith discussed extensively in his remarks in Florida, SB 90 and SB 524. Both of those will significantly impact the ability of Florida voters, particularly voters of color and those with disabilities, to access the ballot box for the midterm elections. I'll do my best not to duplicate too much of Professor Smith's testimony, but to the extent that I do repeat things, I hope that emphasizes the significance of the impact of both of these pieces of legislation on Florida voters and how seriously this legislation should be taken by you folks on the committee, as well as the commission and any interested party at any level of government or any observer. So I'll dive into a little bit about the 2020 elections to provide some context here. The 2020 general election had the highest voter turnout ever reported in Florida. More than 11 million ballots were cast, including more than 1.3 million ballots by Black voters and 1.7 million ballots by Latino voters. Of the over 11 million ballots cast, 4.8 million were vote by mail ballots, more than in any prior election. And the number of vote by mail ballots cast by Black and Latino voters, as Professor Smith mentioned, increased far more dramatically than the increase for white voters from 2016 to 2020. The increase was about 100% for Black voters in Florida. Of the more than 4.8 million vote by mail ballots cast in 2020, almost a third were returned to a drop box. Approximately 485 drop boxes were made available across the state. Many of them, as Professor Smith mentioned, open for 24 hours on the weekends, on the Monday before Election Day, and on Election Day itself. And Black voters were more likely to use drop boxes and to use them during times that early in-person voting was not available. Importantly, and Professor Smith emphasized this, I want to re-emphasize this, there was no evidence of systematic voter fraud relating to the 2020 elections in Florida. There were no reports of any tampering or voter fraud involving drop boxes in connection with the 2020 election. And multiple elected officials, Professor Smith read quotes to you from some of them, including SOEs, the Secretary of State, the governor, have stated that the 2020 election was one of the smoothest and most secure in the country. And this context is really important for understanding why SB 90 and SB 524 are before us. So turning to SB 90, within a few months of the November 2020 election, the Florida legislature passed SB 90, which significantly limited access to the ballot box based on this purported justification of addressing voter fraud. SB 90's restrictions on how voters vote by mail are significant. First, it restricts when drop boxes can be open and requires that they be staffed by an employee of the Supervisor of Elections. SB 90 requires that drop boxes at locations other than the Supervisor of Elections offices can only be open during the hours and days of early in-person voting. Those days do not include the last Monday before Election Day or Election Day. And SB 90 also requires that these drop boxes be monitored by an employee of the Supervisor of Elections. Supervisors of Elections are subject to a civil fine for violation of this provision. In 2020, several counties made drop boxes available outside of early voting hours, and they were monitored by video surveillance when there wasn't an employee staffing them. For example, in Miami-Dade County, they offered drop boxes on the Monday before Election Day and Election Day, including at locations other than the supervisor's offices. These are generally very high traffic times for people to use drop boxes. Thousands of voters deliver their ballots in these final few days. Because of SB 90, Professor Smith covered some of the impact that it will have on the number of drop boxes that are going to be available to voters in Florida, and the availability of drop boxes is going to reduce significantly because of the limitations of SB 90. And that impact will be felt most heavily by Black and Latino voters in Florida. SB 90 will disproportionately burden voters with limited access to transportation, voters with inflexible work hours. Those voters are typically more likely to be Black or Latino voters. It will also impact voters of color, because voters of color are rejected. Their vote by mail ballots are rejected at disproportionately higher rates than white voters in Florida. So direct return of vote by mail ballots to drop boxes is even more important for them. And then finally, this will disproportionately impact voters with disabilities who more frequently rely on outdoor drop boxes to cast their ballots because indoor drop boxes are less accessible to them. SB 90 also restricts how many elections a voter can request a vote by mail ballot for. Prior to SB 90, a vote by mail request would be valid for up to 2 general elections. Most voters opted to receive vote by mail ballots by checking a box on the return envelope for the election immediately after their request and the election that followed. SB 90 changes the law so that a request for vote by mail ballot is only good for one election. In other words, it eliminates standing requests. And this threatens to reduce the turnout of voters who rely on those standing requests and who are more likely to vote as a result. Furthermore, completing administrative forms continuously for each successive election can be difficult for older voters, voters with memory issues, and blind voters, therefore negatively impacting voters with disabilities again. SB 90 also requires that a voter who requests a vote by mail ballot in person, by phone, or in writing must provide certain forms of ID, as Professor Smith mentioned. And they may only receive a vote by mail ballot if the ID number that they provide on their ballot matches the ID number on their original voter registration file. Otherwise, the request is rejected. So prior to 2006, voters could register to vote in Florida even without a driver's license, a state ID number, or a social security number on file. After SB 90, such voters will not have an identification number on file in the system, and therefore whatever number they put on their application will not match what is on the file, and they will be unable to request a vote by mail ballot. This provision burdens several groups of voters. For example, those who are registered to vote but don't have a driver's license, state ID, or a social security number on file. Also, those who have a form of ID on file other than the one that they currently possess. It will also negatively impact those who have an incomplete or incorrect ID on file, those who cannot remember which ID they provided when they registered to vote, those who no longer possess the form of ID that was used to register to vote, and those who are simply reluctant to provide their personal identifying information every time they have to request a vote by mail ballot. Professor Smith mentioned some of the numbers related to individuals, voters in Florida who don't have certain forms of ID on file. Those numbers are extremely significant. Hundreds of thousands, if not millions of voters could be impacted by this requirement. And this provision falls particularly heavily on Black voters. And Professor Smith did the analysis for purposes of his expert report that showed that Black voters are more likely not to have a driver's license or a social security number on file with the Division of Elections than their overall registration rate. So there is now a real world example of how this type of provision might play out. In Texas, in 2021, the legislature passed a very similar provision that required an ID number to be placed on a vote by mail application ballot. Although in Texas, only certain categories of individuals can vote by mail. So a smaller category of individuals, but same requirement to provide an ID number. And there, the impact was extremely significant. Rejection rates were astronomical compared to prior elections in Texas. And there was voter confusion and chaos throughout the primary. So we have a real world example of how this will function, and we can expect similar problems to occur in Florida as a result of this provision. Now, one of the consequences of making it harder to vote by mail is that more people will have to vote in person on election day, thus increasing lines and wait times at the poll. This impacts both people who previously voted by mail and those who want to vote in person but will have to wait longer because more people are there. Florida has historically seen long lines at the polls on election day. Black and Latino voters in Florida generally wait in lines longer than white voters. And SB 90 makes this works. It appears to criminalize the provision of nonpartisan relief to voters waiting in lines, such as food, water, chairs, other types of nonpartisan assistance that the government often does not provide. And this tax will be borne disproportionately by Black voters and other voters of color. The cumulative effect of these provisions is important to consider. SB 90's restrictions on voting by mail combined with the line relief provision and other restrictive provisions of the law will together significantly raise the cost of voting for Florida voters, particularly voters of color and those with disabilities. Now, we've already talked about how there is no basis and evidence for the purported justification of election integrity or voter fraud for these provisions. Sponsors of SB 90 were unable to point to any evidence of voter fraud, drop box vandalism, or election security issues to justify these particular provisions. Now, touching briefly on SB 524, while the trial of SB 90 was occurring earlier this year, the Florida legislature was considering SB 524, and now it is poised to become law. As Professor Smith mentioned, it creates the Office of Election Crimes and Security, which I won't go through all of the details, but it recalls historical instances of intimidation by armed law enforcement and others claiming the power of the law in the voting process. And the prospect of a new law enforcement entity housed in the executive branch and empowered to initiate and conduct independent inquiries and investigations with no explicit restraint on the scope of those inquiries or investigations will likely have an intimidating and chilling effect on voters' participation in the democratic process. SB 524 also makes it even harder to vote by mail by adding certain restrictions on drop boxes. Furthermore, it changes the name of drop boxes to secure ballot intake stations. Now, there's no rationale that would suggest that the name needs to be changed. Rather, the name change will now simply confuse voters who are used to the term drop box and will not be clear on what a secure ballot intake station is. It will require SOEs to change their voter education materials and will impose the cost of time and money on SOEs to make those changes. Now, Professor Smith did a great job of covering a lot of the other provisions of SB 524, so I won't go into detail on those. And I'll go ahead and wrap up, and I'm happy to answer any questions from the committee. But I'll conclude by saying much of this testimony so far has been fairly discouraging. However, there are opportunities to address these issues and opportunities to address them ahead of the midterm elections. First and foremost, this has been in the news, and this has been debated for months now in Congress, but federal legislation setting a baseline for the methods of voting that states must offer would address several of the issues that we've discussed so far today, particularly the issues related to vote by mail. In addition, federal legislation that will restore the pre-clearance requirement that was eliminated by the Supreme Court in Shelby County versus Holder will ensure that future legislation passed by not only Florida, but states around the country does not discriminate against minorities and voters of color. And that will happen before the legislation goes into effect rather than after, and will avoid the need for timely and costly lawsuits to be brought in order to challenge these provisions. So I'll go ahead and wrap up there, and I'm happy to take any questions by the committee. Thank you.
All right. Thank you. I am not muted. Okay, wonderful. Well, thank you very much. And as a reminder, we will do questions at the end after all four of our panelists have spoken. Thank you for that testimony. Next, we'll go to Cynthia Slater, president of the Volusia County Daytona Beach NAACP.
Good afternoon. Again, my name is Cynthia Slater, and I am the president of the local branch of the NAACP in Volusia County, Daytona Beach, and have served in this role since 2001. Prior to that, I served as the branch's first vice president from 1998 to 2000. And in the past, I've also held different roles on the executive committee and as an officer of the NAACP Florida State Conference. I've also served as the Florida State Conference Civic Engagement Chair. I have made it my mission to fight for equality and fairness. The NAACP is comprised of more than 2 million activists united in the fight to end racial inequality. The Volusia County Daytona Beach branch, like all units, are charged to implement strategies and programs to advance the national mission of our organization on a local level. Specifically, we implement the priorities of the NAACP Florida State Conference to ensure the political, educational, social, and economic equality of all Florida citizens. It was stated that the 2020 election was a smooth election. However, voting rights legislation that has passed or in the courts and being challenged are viewed as voter intimidation and voter suppression, making it harder to vote. Florida has a history of disenfranchising Black and other minority voters. There are several election laws changed that have been introduced by the Florida legislature that are of great concern to me as the president of the local branch, and how it will affect voters of color in the upcoming elections and elections that follow. I will speak to the issue with parts of SB 90, which includes line warming, where I provided testimony back in February. Among our many programs prior to SB 90, branches conducted extensive line relief efforts to ensure all voters have access to the political process. Beginning in the year 2000, our organization, in conjunction with the Black Clergy Alliance, hosted a robust Souls to the Polls program to help transport Black and elderly voters to polling locations after they attended church on the Sunday before Election Day. Since then, we have regularly co-hosted Souls to the Polls events with the Black Clergy Alliance. We also work with sororities and fraternities and other grassroots organizations that transport voters, including college students, to early voting sites. Voters in our community have grown accustomed to our line relief efforts, but particularly our elderly, disabled voters, and parents with children who rely on us for refreshments and the physical assistance provided by our volunteers. In our county, in past election cycles, voters have waited as long as 2 hours to vote, which is why line relief efforts are so crucial to our mission. Our line relief efforts are comprised of several different components. We provide refreshments such as snacks, juice, and bottles of water to individuals waiting in line. We also provide items such as fans, chairs, and umbrellas to voters waiting in long lines at polling locations. By supplying food and water to help sustain individuals waiting in long lines, the NAACP and its volunteers are not only providing voters with support and a respite, but also communicating that it is important to stay in line to exercise their right to vote. Additionally, as part of our line relief efforts, volunteers assist voters with disabilities, including visually impaired voters, voters using canes and other mobility assistance devices, such as wheelchairs, by walking with them to the polling site or helping them move to the front of the line. Volunteers assist elderly with chairs for resting purposes, or if they need to step out of the line to use the restroom, by coordinating with other voters to save their place in line. Our volunteers also assist parents by entertaining children while their parents wait to vote. In support of all of these efforts, our branch provides extensive training to volunteers. Our training efforts includes explaining when to respond to voter questions, when not to respond to voter questions, when to assist voters, when not to assist voters, how to spot significant issues, and when to contact our state and national offices. In past elections, voters in line were the subject of intimidation tactics. Our volunteers are trained in how to assist in situations such as this, including seeking the help of law enforcement. I believe the mere presence of our volunteers assists voters who would otherwise be intimidated to stay in line and exercise their right to vote. This case, the SB 90 line warming case, was heard, but it has not yet been ruled upon. I concur with Professor Smith and legal counsel for the NAACP, Badat, about the SB 90 as well as SB 524. And we have questions with SB 524 where it creates a 15-person Office of Elections, Crime, and Security to investigate fraud complaints in the Secretary of State's office, which reports directly to the governor, adding 10 state police officers chosen by the governor to augment the office, requiring election supervisors to clean up their voter rolls annually rather than every 2 years, and making some elections crimes, a third-degree felony punishable by up to 5 years in prison instead of a misdemeanor. Another thing that we're concerned about, it makes it difficult to request a mail-in ballot, and it makes it more difficult to register new voters by third-party registration groups such as the NAACP. Not only do we see this as voter intimidation, but it is also voter disenfranchisement. If the 2020 election went as smoothly and with minimal incident as it has been claimed, then why the drastic changes? Election laws should be put in place to make elections run more efficiently, not more problematic, where it is seen as practices of disenfranchisement. Thank you for inviting me today to provide testimony and to share with you what we experienced during the line warming process.
Thank you very much. And finally, we turn the stage over to Wesley Wilcox, Supervisor of Elections with Marion County.
Thank you, Chair Smith and commission members for having me here this afternoon. It is truly an honor to be here and participate in this forum. I will keep my remarks extremely brief as I did not prepare long statement, or not long, just statements as some of the other presenters did. I will echo a couple of the items that have been mentioned, I believe, by all speakers. The state of Florida, I feel in my capacity as supervisor of elections and supervisor for a couple of years now, that the way that the professionals in the state of Florida conducted the election in 2020, I think was a national model. We heard from our governor, as well as our secretary of state, as well as national media, as well as other pundits, highlight the efforts that Florida made, especially from the year 2000 to the year 2020, and the turnaround that Florida has made in the conduct of elections. I will tell you, as Professor Smith stated, we as Supervisor of Elections did not support SB 90. We didn't support it when it passed, nor do we actually support it in its current view, but it is being litigated, and we will see how that flows through there. One of the other items that I think we need to be completely concerned with is a proliferation of what we in the election profession are calling MDM, which is misinformation, disinformation, and malinformation, where people are purposely, specifically malinformation, where people are purposely using a nugget of truth and then distorting the context and when that nugget of truth is, and possibly a way to dissuade people from participating in our electoral process. We're the strongest as a nation, as a country, when the vast majority of us participate. The more participation we have, the better our democracy is, our republic is. And so, we as supervisors of elections don't come down on a political side one way or another. Our sole purpose is to facilitate our democracy and to ensure that everybody that wants to participate, we get them to participate and hopefully make them feel welcome while they are. So with that, I will conclude and open it up to our next steps. Thank you.
All right, thank you very much to all of our panelists. And I want to go ahead and remind our committee members that we'll each get one question, and if time permits, we will give members an opportunity for follow-up. All right, so with that being said, I'll count on staff to help me with the hand raising function because I can only see 3 or 4 people at a time. So
Chair Smith, I recommend starting with the roll call so you're able to go through everyone and then circle back as needed. But if you'd prefer to switch, that's up to you as well.
I appreciate that, and I actually will follow that. Let's start with Committee Member Warren Belmar. Do you have a question for the panel?
Okay. Yes, I do. Actually, I've got a few, but thank goodness we seem to be moving quickly so that we should have plenty of time till 4 o'clock to allow for more active participation by all of the advisory committee members. One point that came through loud and clear to me, and I'm glad to see that all of the people testifying agree to it, and I do also, that the 2020 election was extremely well run, and that a lot of the concerns that were reflected in the report and recommendations of this advisory committee in 2020 proved not to be as much of a concern as they were when the report was written, by virtue of the way the election turned out. So that a lot of the concerns that were expressed with respect to disadvantaged individuals, disabilities, and people of color turned out to not be as bad as the report and recommendations had indicated. But now you've raised a very interesting issue, and I'd like all four people to explain to me one point with respect to one of the changes that everyone focused on, which had to do with absentee ballots. And I was concerned with the numbers that were expressed as to people without identifying information on registration with the supervisor of elections, so that when they requested an absentee ballot, they were unable to obtain one. And the question I really have on that is, if today, 2 years before, well, now it's closer to the election, but before the presidential election, let's say, if I request an absentee ballot and I'm told that the information is not on the registration information at the supervisor of elections, can I not just then simply say, oh, excuse me, here's the information. Now that you have it, please send me an absentee ballot. I'm just not understanding what the problem is when someone asks for something and was told they can't have it because you haven't given us your number, your social security number, or whatever the identifying information is. And couldn't the person just promptly correct it? And if so, is the problem not of the magnitude that was expressed and concerned by our testifying people? So that's my question to each of the four testifying individuals. Thank you.
All right, who wants to go first?
Sure, I'd be happy to speak on this briefly. You raised some very good points, Mr. Belmar. I would agree that the 2020 general election did not have problems that we have seen in the past, specifically the 2012 general election with very long lines during early voting, which was the direct result of the truncation from 14 down to 8 days, including the elimination of the final Sunday of early voting. Part of that was because of the shift to vote by mail ballots because of the pandemic. And the supervisors did a remarkable job of transitioning voters from voting in person, either election day or early, to the online modality. They did that in the presidential primary in March. They did that in the August primary in preparation for this record turnout that we had, over 11 million voters in the general election. The other thing that really helped in terms of the ability for voters to be able to have their vote by mail ballots cast, something that I have raised questions about and have actually documented twice the rate of rejected vote by mail ballots cast by Black and Hispanic voters in the 12 and 16 general elections, as well as the 2018 elections. That was reduced so that Black and Hispanic voters were on par with respect to the percentage of their vote by mail ballots that were rejected. And that's because there was a very active cure process that went on. Part of the reason why that curing process, which voters have up until 2 days, 5 p.m. after election day, to have their ballot corrected if there's a missing or mismatched signature, as long as they're on time, was because ballots got to the supervisors earlier because they were moving towards drop boxes. And so supervisors were processing, they were clearing vote by mail ballots, canvassing boards were flagging them if they had problems, voters were being alerted by supervisors as well as voting rights groups to be able to process that. And so that was remarkable and really helped. And I think part of that was because we had vote by mail ballots coming in at an earlier rate, partly because of the tremendous effort by the supervisors to provide 24/7 drop boxes that were secure outside of their offices, other locations, including early voting locations and whatnot. To the point of this question of, by the Secretary of State's own admission, over 680,000 individuals who do not have a voter ID on file. There's a vast number of them who actually do vote by mail. They were able to validate their identification but they did not have a social security number. Not everyone has one. Some people have social security numbers that have been compromised and they've been issued a new social security number. That social security number is not going to be on file when they registered, for instance, with the last 4, if you've been issued a new one. Some people are issued a driver's license. Some people have that driver's license taken away from them because maybe they can no longer see and their family takes it away from them. They would not be able to request a vote by mail ballot if they do not have that driver's license number available to them. So it actually has nothing to do with updating. If you don't have an ID, you cannot request a vote by mail ballot. And we're talking, at least by the Secretary of State's own numbers, over 500,000 individuals.
No, you said 500,000 individuals.
Warren, yeah, you gotta go continue, Professor Smith.
There are lots of different categories of individuals. The Secretary of State's office identified through discovery process in the litigation 681,000 individuals who do not have a social security number, a driver's license, or a state ID on file, and yet they are properly registered to vote. Pinellas County has 28,000 individuals of such. No ID on file. I did analysis of the Pinellas County. I want to say about a third of the individuals actually voted successfully by mail in Pinellas County. People who do not have an ID that under SB 90 can now not even request a vote by mail ballot, much less vote one. If you do not have an ID, you cannot request a vote by mail ballot under SB 90.
Thank you. Who wants to go next in responding?
I'll
Amir?
go next.
Okay.
Chair Smith. Wesley
Oh, good.
Wilcox, Supervisor of Elections in Marion County. I noted 2 items, Member Belmore. First off is, let me use a term that we use more accurately today, and it's vote by mail as opposed to absentee. I rarely use the term absentee anymore just because of the connotation that somebody needs to be absent, and that's just not factual. So I very often try to always use the term vote by mail. In your scenario where a voter calls me up to request a vote by mail, you're completely accurate. At that point in time, if I do not have your identifying documents and you have them, I can do that identification at that point in time. I will tell you, I'm one of the jurisdictions in the state of Florida that has relatively few voters without a DL or last 4 of social. Just because it's been a project of mine, I think it's an important piece of information, and therefore we in Marion County worked hard toward that. The challenge that it faces to me is, unfortunately, a lot of voters and the parties, the both major parties in the state of Florida, usually in the September timeframe, they will do out mailings to their members who haven't signed up to vote by mail, getting their members to sign up for the vote by mail process. And most of those are done on a postcard type mailing. And, at that point in time, without having that identifying mark back or that identifying information in my voter record, that mailing is not going to happen. Or at least it's going to fail for those that I don't have that information on. And so that's a problem. The other challenge that out of this a little bit is I've been one of the jurisdictions for a number of years now that put the checkbox on the vote by mail ballots. I can't remember if it was Professor Smith or one of the others that mentioned that, but I do that. I have done that as well. And my thought process here is, if somebody has voted but is voting by mail, and that means I've got the envelope with their identifying information and signature on it, and then if I accept that signature as matching that voter's record, why could I not at that point in time also institute an additional vote by mail request for the next election? I validated you. I know who you are. I've matched your signature. And therefore, I'm confident I've got the right person. And I feel it would be appropriate at that point in time to go on and do a future vote by mail request since I've identified your voter. Hopefully I answered your question.
Thank you. Let me just see if Amir or Cynthia would like to respond also.
Okay, thank you. I just wanted to, we're, as volunteers, we're pretty much more boots on the ground than anything. And I think one of the most important things in doing voter participation is having that relationship with your local supervisor of elections. And we have an excellent relationship with our supervisor of elections office. And although there may have been some minor problems with voters that vote by mail, again, as you said earlier, one of you said that supervisor of elections, the law gives you 2 or 3 days to correct that. The supervisor of elections office will contact the voter and they will be able to correct whatever is wrong with the with your ballot. But with this new law, it will really hinder elderly people or those individuals who don't have an identification to not be able to vote by mail. And so I just wanted to add that I think the professionals in this field have said it all. We're boots on the ground, and we do as much as we can to assist and to show the supervisor of elections office in our area that we're working on trying to make this right and make everyone be able to vote. So I concur with everybody else.
Thank you. Let's see if we can get Amir unmuted.
Okay, I think I'm unmuted now. Sorry, I wasn't able to unmute. The only thing that I would add, and I think my colleagues have covered it mostly, is I would just go back to what I mentioned during my remarks that, you know, we have now an example of how this provision actually plays out. And we saw what happened in Texas in the March primary. Again, there, only a limited category of individuals can vote by mail. You have to be over 65 or disabled or fall into some other category, unlike in Florida. And so, but nevertheless, the rate of rejection in Texas was still about 13%. And that's after the opportunity to cure your ballot. So if we, you know, extrapolate that to the levels of vote by mail that we saw in Florida, which were in the millions, well, you know, nearly in 2020, nearly 5 million people cast vote by mail ballots. A 13% rejection rate, or even a 10% rejection rate, or a 5% rejection rate would result in the rejection of tens of thousands, hundreds of thousands of ballots. So that is a significant concern, and I think it's something that that should be discussed and addressed ahead of the midterms.
Right, thank you. I want to go ahead and move to our next board member and see Brad Brown. You have questions for our panel?
Yes, I'm now unmuted, right? Can you hear me?
Yes, and Brad, I want to just give a reminder to all of our panelists to take care that we actually have a question, not a speech folded into a question. So I just want to remind folks to really direct your questions to the panel. The floor is yours, Brad.
Yes, my question is I'd like a response from all of the panelists, specifically addressing how they see as an impediment the requirement that a third-party registration effort is required to give in writing or tell any person that they're registering that the third party may not get their registration in on time. And then specifically to what happens if that person who is filling out that registration wants to take that registration and mail it in rather than leave it with the third party, which is required by law to turn that specific ballot with its number back into the registration office. Thank you.
All right, Professor Smith, you want to go first?
Excuse me. Thank you, Member Brown. This is a very important question that you have. I think we just need to start off by recognizing that these third-party voter registration organizations play a very important role in Florida as well as across the country. We do not have automatic voter registration in this country. Nationally, we have it in some states where you can opt out, but we are not a country in which once you are a citizen and eligible, you are issued a voter ID card. And as a result, you need to do it as an individual. Many people do it when they turn 16 and pre-register. Many people do it at the driver's license office when they get their driver's license. Many people do it when they become naturalized citizens. And we have lots of places you can do it. You can do it at the Armed Forces recruitment centers or public libraries and so forth. But we have lots of individuals who fall through the cracks. And by lots, I'm talking about 750,000 individuals currently have registered with a third-party voter registration organization as their last point of registration. It could be a new registration or an updated one. There are millions more over the last decades that have used third-party voter registrations and then may have updated the registration at the DMV. But we're talking currently about 760,000 individuals. Of those, disproportionately, they're more likely to be Black and Hispanic than white, 5 times more likely. So as of this summer, last summer, when looking at those numbers, there were 220,000 Black individuals who registered with third-party voter registrations, 222,381 to be precise. There were 253,370 Hispanic individuals. There were 173,616 white individuals. So about 11% of all Black individuals registered as of the summer actually had last registered with a 3PVRO. About 9.6% of Hispanic individuals registered in the state of Florida had registered with a 3PVRO lastly. Less than 2% of all white individuals have registered with a 3PVRO as of last summer. So you can see that this falls disproportionately on groups who are registering individuals who do not have the same access or opportunities to register to vote as other individuals. It becomes really problematic when the state puts these fines and fees, criminal possibilities with respect to felonies on individuals who are registering individuals to vote. We need to make sure that the process is legitimate. We know that there are some bad actors out there who do register voters because maybe there's an incentive basis on filing in registrations. But you know what? We have really good supervisors of elections who are able to vet those, and they're able to find them. And they did so prior to SB 90. By putting these additional requirements of either language that under SB 90 people had to say, I may not get your registration in on time, or now building it into the actual forms themselves, is a chilling effect on these groups. We know that groups are not going to be out there as aggressively as they've been in the past to register voters, usually 2 months before an election day, that window of a month before the 29-day cutoff, because of these draconian measures placed on civic groups. They are our aunts and uncles that are out there at community fairs, at churches and synagogues, who are registering people who are new to Florida, who haven't yet registered, who are had fallen through the cracks. And so I find this to be very targeted and very deliberative in terms of who actually relies on 3PVROs.
All right, thank you. Just following the previous order is Supervisor Wilcox. Would you like to weigh in?
I have nothing further to add that Professor Smith has not already covered. Thank you.
Thank you. Okay, Cynthia Slater, would you like to weigh in? No? Okay. And Amir Badat, would you like to weigh in? All right, thank you. And moving to our next, let's see, Thomas Newcomb Hyde, would you like to pose a question to the panel?
So one moment, it looks like Liliana is unmuting you again. So Thomas, keep an eye out for that request, and then you'll press unmute.
Doesn't look like he's unmuted.
Okay, so Thomas, you'll want to, that's right. Okay, it looks like you're unmuted now. Great. Okay, so Thomas, I think you might be hitting mute twice. So wait one moment. Liliana is going to send you a request to unmute, and then you'll just want to accept that on your end.
And not touch the mute button again.
That's right. So let's just wait one moment. I think Liliana is sending it again. Okay. All right, so one more moment. I just selected unmute all. Thomas, can you try unmuting yourself one more time? There we go.
There you go. Don't touch anything else. Oh, you were good there for a moment, Thomas.
But you should be able to unmute yourself if you just select it once.
You're good. Okay, we're going to come back to you. There's, let's see, we're going to come back to you, Thomas. Charlie Taylor Hill.
Okay, I have my one question is around examples of what one of the organizations, grassroots organizations, would do that could possibly get them charged with a violation of SB 524, SB 90, and get them charged with a felony. I mean, what would they actually do? Give me some examples of that so I understand what that looks like.
All right, which one of our panelists would like to take that question?
So I will, can you hear me?
Yes.
As far as SB 90 and the line warming, it is, they're saying that we as volunteers cannot hand out water and snacks and fans and umbrellas and all those things that would assist a voter from getting out of the line. And I think that they're thinking that we as volunteers go up to the lines where those voters are and just start handing out water with probably the NAACP's name on the bottle of water or a candidate's name on the bottle of water, but that's not how it works at all. We have tables and stations set up at a certain distance from where the restricted lines are before and the voters will come to us and ask if they could have a bottle of water or whatever. And so I think they're being misunderstood and not understanding that we just don't go and we don't just go and stand in line. I mean, just go up to the line and just start handing out bottles of water. And so that's one of the things that I believe that these legislators don't understand when it comes to us assisting with line relief efforts.
All right. Thank you. Any other panelists want to respond to the question of what would actually trigger a felony charge by nonprofit organizations? Okay, Amir.
Yeah, I can provide a couple of examples. One example that will now trigger a felony charge under SB 524 would be what some folks have called vote harvesting, which is really just returning more than 2 vote by mail ballots that are another voter's vote by mail ballot. So, for example, if the voter is not your family member, so for example, if a pastor or a neighbor returns a vote by mail ballot of one of their congregants or their neighbor or multiple people in a household before SB 524, so under current law, that is a misdemeanor. SB 524 makes that a felony that could result in significant jail time for someone who is simply returning someone else's vote by mail ballot. Likely a good citizen who is trying to make sure that their neighbor or someone else that they know can cast their ballot. Now, this isn't criminal penalties, but with respect to SB 524's fines on third-party voter registration organizations, that it increases the cap on the fines that third-party voter registration organizations can suffer to $50,000. So what could trigger one of those fines is simply returning a voter's registration application after the 14-day window in which that application is supposed to be returned. So those are the types of small minor things that could actually result in either a fine or some type of liability.
Thank you. Supervisor Wilcox, I think you're...
Amir covered the items that I was going to cover. Thank you.
All right.
And I just have one other, again, seemingly minor, but with pretty major consequence with respect to the possibility of the $50,000 fines. If a third-party voter registration organization, say, is registering an individual from Broward County who happens to be a student at the University of Florida, and they're doing voter registration drive, and people are putting down their local address here in Gainesville, doing that correctly. But one voter decides that she wants to register where she's lives in Broward, where she grew up, and is planning on going back there after graduating in May, before the August primary. So she wants to update that. The third-party group collects all these, and they drop them off at the Alachua County Supervisor's office. They are actually in violation of SB 90 for returning a vote by mail application to the wrong supervisor. In the past, the supervisors would have these. They would talk to the supervisors. This happens. People return theirs to the wrong supervisors. In fact, voters themselves may return an application to the wrong supervisor when they're updating it, thinking that that was fine. That, I guess, is okay under SB 90, but it's not okay if you're in possession of someone else's vote by mail, voter registration application, and you drop it off. Then you are subjecting yourself to thousands of dollars worth of fines. Again, these are good Samaritans. There are people out there trying to register and update people. It seems to be a very small little problem that can be easily remedied, and is, by supervisors, and traditionally have taken care of this, but there's been a crackdown on this.
All right. Thank you very much. I want to go to member Linda Kidwell, and then we'll double back to you, Thomas. The floor is yours, Linda.
Thank you very much. I should preface this by saying I have to leave in 5 minutes. So if I leave while you're answering my question, I assure you I will read the transcript. My question is mostly for Supervisor Wilcox. And you were noting that you have already seen the signature, you've already validated that that voter and is who they say they are, and the checkbox that that should be sufficient. But in your statement to that effect, you concentrated on the older voters who are maybe in the habit of doing that. But as a college professor, I'm thinking more of the young voters who move frequently. And therefore, how do you propose that, or how would that impact this sort of situation? I think one of the concerns may be that people check that box, but they move, and then the ballot goes to their old address, and somebody there fills it out on their behalf rather than returning it as they should. So how do you address that problem if you continue to allow the checkbox method? Thank you.
Member Kidwell, thank you very much for the question. Very, very well thought out. You know, if I mail a vote by mail ballot to Jim Smith at college or whatever else, only Jim Smith can return that ballot. So if it gets there and it's undeliverable, first off, ballots are not forwardable. So if it goes to a location and it's undeliverable via the United States Postal Service, that ballot is going to come back to me. If it's a local voter, I will mail them a letter, say, hey, you requested this, do you really want to vote by mail, and we'll update the address. If they move to another jurisdiction, say they were going to school here and move back to Broward, I'm going to cancel the request at that point in time. And so I won't mail one like that. But for some reason, the postal, you know, you mentioned college age, you know, going to a dormitory where people move a lot, or apartments where people move a lot, and the postal people don't know who lives there this week. You know, it's true. If those come back from somebody signed other than who I sent it to, it's not going to be accepted, because the signature on the record, that envelope that I mail is your envelope. It's nobody else's. And so therefore, no one else could take that right away from you on voting that. I think it's probably a larger challenge in the jurisdictions that you mentioned that have a extremely mobile population. You know, something that people don't just recognize, that about 10 to probably 12 or 13% of our population moves about every 2 to 3 months. I mean, it's just what they do. And so we get those type of things and those updates at all times. And but the amount of the detriment to that is I mailed 90,000, which was a record vote by mail for Marion County. We did over 90,000 returned vote by mail ballots are mailed out on me. And so by requiring the other 80,000 now that I'm going to do, 80,000 are going to have to now be proactive to ensure that 10,000, just using those numbers, are not mailed a ballot and it returned to me as undeliverable. I don't know that's really there's that great of a return on investment. My 80,000 that continue to vote by mail, that lived in the same plantation or they're the same apartment, same wherever for 25 years, are going to continue to go there. I don't know that this solves the problem that we have, in my opinion. Thank you.
Thank you. Any other panelists want to respond to Member Kidwell's question? I'm not seeing a hand raised, so if you're not jumping in, I'm about to go back to.
So Chair Smith, I believe we have Professor Smith who's raising his hand at this time.
Oh, wonderful. Thank you so much for helping me out. I really cannot see.
Yes. Member Kidwell, a very good point. And I want to go back and re-emphasize what Supervisor Wilcox was mentioning about that check on the back of an envelope. now that we do not have that check, there's been a grandfathered in period of time to allow people who are what we might call perpetual or permanent vote by mail voters. They're not really permanent because they have to keep updating, but it's a phrase that we often use. People who are routinely on the vote by mail list and they check off their box because they're voting, and on that return ballot, as Supervisor Wilcox said, he is using that, his staff is using that to verify the voter and to have that individual prepared to be issued a vote by mail ballot without preemptive requirements. If you now look at this requirement that people who have this standing request to have a vote by mail ballot, they will have to request a vote by mail ballot, not just for every general election. They potentially are going to have to be doing this for municipal elections, special elections, presidential primary elections. In the past, they would have those all built in, but now it is these requirements under SB 90 to do these continual requests, either by mail or online, in order to do this. So it's adding this extra layer that's not really doing anything with respect to security. That is already built in prior to the place. It's now just an administrative burden on the supervisors, and that's what I'm hearing from them, is that it is going to put an even greater cost when they're trying to get everything else ready for the election, including the ballot preparations, the early voting locations, the election day centers, precincts, and yet it doesn't really do anything with respect to security.
Thank you. Any other panelists wish to respond? Going once, going twice. We return now to Thomas. Let us try again.
Okay, Tom, I just sent you the request to unmute.
Okay. Just take a moment. And while we're waiting for that unmute, I think it's will come to me and then Michael Morley for question.
Tom, I'm going to send it one more time. The request, I mean. And you'll want to make sure that you just press it once by accepting the request to unmute.
You are good. Go ahead and speak, Thomas. You are live.
I just want to ask Attorney Badat and Professor Smith about the federal legislation on voting requirements, state voting requirements. Can you tell me why that's not unconstitutional?
Okay. Who? Go ahead, Mr. Badat.
Thank you for your question. So Congress actually has the constitutional authority to regulate elections for both presidential and congressional elections. So the baseline requirements that would be included in the federal legislation that I referenced would fall under that authority that Congress has. So Congress would be legislating pursuant to their constitutional authority to regulate federal elections.
And I believe Professor Smith, you were also asked if you could respond.
Yes, it's the time, place, and manner clause of the U.S. Constitution. And generally, the convention has been that not only those elections that have federal candidates on, but also local non-federal races will also follow those same standards. So yes, the federal government still has quite a bit of power over the broad framework of elections in this country, as we've seen repeatedly. One could argue that the U.S. Supreme Court has certainly scaled back some of those protections that have been around since certainly the 1965 Voting Rights Act, most notably with the decision in 2013, the Shelby v. Holder decision, which undercut much of the ability of the federal government to regulate elections for covered jurisdictions. Florida was not fully a covered jurisdiction, but 5 counties in Florida, if I remember them correctly, Holmes, Hendry, Monroe, Collier, and Hillsborough were all included under Section 5 of the Voting Rights Act in 1975 for problems with respect to access to the polls for Black and Latino voters. As a result, all of Florida was covered by Section 5 of the Voting Rights Act because we run statewide elections with the same rules. Again, that has been challenged, and it has made the role of the federal government more limited with respect to some of these changes that we're seeing. For instance, had SB 90 been passed prior to the passage of prior to the decision in the summer of 2013, the U.S. Justice Department would surely have been triggered, or a federal judge would have been asked to opine on whether or not this was in violation of the Voting Rights Act. I'm wading into an area that is much more the area of my colleague here, Amir, but as he's a constitutional law professor and I'm just a mere political scientist.
All right. Thank you very much. I'll go ahead and ask my question of the panel. You've each referenced a disproportionate impact of these changes specifically to Black voters and people with disabilities. Does your research point to whether this is happenstance that these disproportionate impacts are occurring, or is there any evidence that these changes have been selected very specifically because there is an intention to have a disproportionate impact? And Professor Smith, you're still on the screen, so I'll let you go first and we'll go from there.
I am an empiricist. I look at how laws impact individuals. I use data, big data. Florida has, unlike many states, the race and ethnicity of voters, their age, their gender, their party. I am able to use these data to look dispassionately at the impact on certain laws or rules that are in place. I've done that with respect to the restrictions that were put on third-party voter registration organizations back in 2011 with House Bill 1355, I think it was, that made it very difficult for groups to register voters there. And I was able to show quite clearly that Black voters were less likely to be registered when third-party groups were not on the ground because they were fearful of being fined out of existence. I've looked at the impact of curtailment of early in-person voting that we saw also with that House Bill 1355 in 2011, which went into effect in 2012, in which we had individuals voting on that final Sunday, even though it was prohibited because they were in line since 7 p.m. on a Saturday and didn't cast their ballot until 1 or 2 in the morning. In line for a minimum of 5 or 6 hours, but likely longer than that because they had to be in the queue by 7 p.m. I've looked dispassionately at vote by mail ballots and the rejection rates of Black and Hispanic voters compared to white voters, young voters compared to old voters. I don't think this is the intent of supervisors of being discriminatory. I don't think it's necessarily the intent of having a signature check that the legislature, when it allowed for vote by mail ballots, moving from absentee ballots and the requirement to be out of a jurisdiction, to be racially discriminatory. The fact that it's a 2-to-1 ratio of Black and Hispanic voters having their ballots rejected in the white could be other reasons. It could be other factors with respect to postal service not being as fast, access to the drop boxes being restricted, for instance. So these are things that you do not have to look necessarily at the intent, and I'm not one who actually does. But certainly there have been examples in which the intent was pretty clear. Africans are more likely to walk 200 to 300 miles in the desert to cast a ballot, as the sponsor of House Bill 1355 said back in 2011 May. But we don't hear that on the floor of the legislatures that often anymore. And I don't really think we need to look always at the intent. We can look at the actual effects. And we know very clearly that the effects do not fall equally across individuals. Resources that individuals have differ. It does not therefore make everyone's ability to participate in the electoral system equal. So I'll leave it at that.
Thank you. I'll go now to Amir Badat.
Thank you for that question. I think it's a really important one for us to think about. And first, I just want to agree with Professor Smith that we don't need to look at intent from both kind of a practical perspective and a legal perspective. The Section 2 of the Voting Rights Act implements what's called a results test. So it looks at the results that certain election provisions or redistricting maps will have, and the impact that those laws will have on minority voters. So, as an initial matter, I just want to agree there with Professor Smith that from a legal perspective, all we have to show is that there's a disproportionate impact, along with several other kind of things that we have to, pieces of evidence that we have to show, but we do not have to show intent in order to establish a violation of Section 2 of the Voting Rights Act. That being said, I think that there are several aspects of the law and the process through which the legislature went to pass the law that would suggest that there was an intent to discriminate here. And again, I'm focusing on the legal definition here of intent. In order to show intentional discrimination, courts use a test taking into account certain factors that were announced by the Supreme Court in a case called Arlington Heights. And several of those factors, I think, were pretty clear here. And I'll note first that intent is a very difficult thing to establish from an evidentiary perspective. It's very difficult because of what Professor Smith said. We don't really have legislators anymore saying that we're passing this law because we don't want Black people to be able to vote. That's just not what legislators say on the floor of these state houses. Nevertheless, there are factors that allow us to take into account circumstantial evidence that help prove intent, that courts find relevant to establish intent. So one of those things is foreseeability of the disparate impact. So here for SB 90, there was testimony presented before the legislature about the impact that the provisions that we've been discussing today would have on Black and Latino voters in Florida, on disabled voters in Florida. And that testimony was presented to the legislature in droves and was considered by the legislature as they were debating the provisions that we're discussing here today. And with that information in mind, they nevertheless passed the provisions. So that's one factor to consider when we're thinking about intent. Another factor to consider is, let's look at what the justification they provided was. The justification that the legislators here provided was that they want to address voter fraud or election integrity. Now, as we've discussed today, the evidence of voter fraud in the history of Florida's elections from a systematic perspective just isn't there. Now, there are some rare and sporadic incidents of voter fraud in certain circumstances over the span of years. But when I say rare, I'm saying the incidents of voter fraud that we're talking about are when we think about the overall number of votes that have been cast in prior elections, we're talking about 0.000%, 0.0001%. Lots of zeros after that point. I don't know the exact number, but lots of them. So when we think about whether or not the legislators were really concerned about voter fraud and election integrity, we have to take into account the evidence that they were citing to. And that evidence just wasn't there. So what we would say in legal parlance is that they were providing a pretextual reason for passing this legislation. And that is another indication of discriminatory intent. There are other factors as well, like procedural irregularities that the legislature used to pass the legislation, and the disparate impact, the actual disparate impact that it creates. All of these factors point towards a finding of discriminatory intent in this case.
All right, thank you very much. I'm going to go ahead to final member Michael Morley, so that you have time for your question. The floor is yours. I think you're on the phone. If you are, you've got to press *6.
Hello, can you hear me?
We can, Michael, go ahead.
Okay, great. Thank you very much.
And now, go ahead.
I'm getting all the automated messages from the system here. Several of the witnesses have testified about the other bill that creates the new office to investigate election-related offenses and election-related problems and things like that. And based on the testimony, I was curious, were there any sort of restrictions or limitations or other sorts of changes that would eliminate or reduce what several witnesses testified was the potential chilling effect or potential burden on rights created by having an office that specifically focuses on that kind of stuff, or is that just inherent in the notion of having investigators specifically focused on those issues?
Yeah, thank you. Who'd like to respond to that question? Don't be shy. The floor is yours, Professor Smith, if you would like. Okay, go ahead.
I have not dug in as deeply as I should on SB 524 and this Office of Election Crimes and Security. My understanding is there's a lot of duplication. We already have the Florida Department of Law Enforcement, FDLE. We have state attorneys who are able to investigate. We have SOEs who are able to refer these matters, and they do. We have seen that there were a couple cases in Lake County where the Supervisor of Elections, Alan Hayes, has identified individuals who were registered to vote in another state and cast multiple ballots, one in New York and one here, one in another state. And those individuals are facing charges. And that's because the system works. It may not have been preemptive, but neither would this task force or this Office of Election Crimes and Security be preemptive. What is more of a concern is how it may create chilling effect by investigating spurious or completely fraudulent claims of voter fraud. There are no regulations really on whether or not they can make these allegations or need to make these allegations public. That can create all kinds of problems prior to an election. It can cause all kinds of misdeeds to be used to utilize this force to make it look like elections are not secure. We know what happens in that case. That leads to individuals not participating, as Supervisor Wilcox made clear. So I think it's a duplication. These are non-sworn officers as opposed to officers of the court who are in charge of doing these investigations. It also could lead to investigations of supervisors' offices, which I think is also quite troubling. We've had individuals here in Alachua County who work for the supervisor's office doing their constitutional duty and registering people to vote who have now been accused of registering people who are ineligible. Of course, by the system is able to vet these individuals who are being registered who may have committed a felony, for instance, and haven't had their voting rights restored. The system is effective in terms of weeding these people out. So I think the general fear is that this is going to become a political force. It's under the governor's authority. Governor appoints the Secretary of State who has authority over this office. And I think that's where the real concern is. What is the need for this office when the system in place seems to be identifying individuals who may have cast a second ballot? Again, it does happen. It's very rare. The system has revealed individuals who were changing people's voter registration on voter registration forms. So the politicization of non-sworn officers working for the Secretary of State, who is a political appointee, is I think where the greatest concern lies, and we don't really know how it will play out. I don't know of another state who has such a task force, a ready response force to investigate high crimes and misdemeanors.
Thank you for that response. I just want to pause here to see if we have any public participants who have joined the call.
Thank you, Chair Smith, and I'll quickly check the participant list. And I can confirm we do not have any members of the public who've joined at this time to share comment. I'll turn this back to you.
Thank you. We just have 5 minutes left, and I want to open it up to members who would like to raise their hand and ask any follow-up question. Please keep it brief in the hopes that we can field a couple of them. And staff, if you will help me identify who has raised their hand. The hand raising is at the bottom next to your share button. And Warren, I think I just saw your actual hand go up. So if we can unmute Warren, and again, please ensure that it's a question and not a speech wrapped up and disguised as a question. But go ahead, the floor is yours, sir.
So it looks like we might need to send that one more time. And Warren, if you can just press mute once you receive the request to unmute. So Warren, sorry, it looks like you're still talking. Liliana, can you send the request to unmute one time? And Warren, you only want to select mute once when it comes through.
And while you're doing that, I'm just wondering if we might just throw all of the mutes off for these last 4 minutes.
Sure. Liliana, I'll take care of that.
Okay.
All right. So Warren, just select mute one time, and that should enable you to talk. It's at the bottom left of your screen near your video button.
All right. And while Warren's
Okay, I
doing
got
that,
it now.
There we go.
It wasn't coming
Thank you.
through before. And Nadine, thank you for running an excellent meeting, and I appreciate the opportunity to speak further. And the question I have is, a lot of the concerns that have been expressed, and I understand them, have to do with the way in which the statutes, which the legislature has already adopted, will be implemented. But we don't know how they'll be implemented until they actually take effect in an election. So while I respect a lot of the concerns that have been expressed on what might happen with respect to things like the investigative bureau or limiting whatever it might be that is of concern, just how concerned are our panelists that the kinds of things that they're anticipating will actually occur, and what would they have us do in a report about things that haven't happened yet, so that we don't know if the facts are there to underline any recommendations on changes in the things that we're concerned with.
Supervisor Wilcox, is that something you want to respond to? And no is a perfectly fine answer, but by all means.
And I thought that was extremely a good capture of this, because a lot of the implementation, you're correct, we haven't gone through yet. You know, a lot of the SB 90 implementation will not take effect. I mean, we've had some of it, but the full of it is not going to happen until 23, when vote by mail requests go away and we start doing some of the other things. So you're exactly correct. One of the challenges I have with SB 524 is that because we haven't gone through one complete cycle with the remnants or with the outcomes of SB 90, why go and make another change before we even see what the implementation of the SB 90 is? So one of the major challenges of SB 524 are making changes on top of changes. I'm a very slow moving person in that if we make a change, I want to do one change and let's walk through and see what it is, evaluate good, bad, ugly, and then attempt to make adjustments as we see fit. We did this in the state of Florida for over 16, 18 years. We'd make a change to vote by or early voting, and the first thing out, it went well. Next one, they came in and really shrunk it down. That did not work well. As mentioned, we had long lines. And so we've gotten to this happy place to where we can fit the needs of a Lafayette County and we can fit the needs of Miami-Dade County. So you're right. A lot of the SB 90 stuff has not been vetted, has not been walked through actual implementation. But some of them are, I don't know that I need implementation of some of it to understand some of the ramifications. Removing future vote by mail requests, I already know what's going to impact me, and that I'm going to have to do something proactively, either to reach out to my voters or do something that I was doing with the prior mechanism, really through virtually from a conservative standpoint, for virtually no cost. And now I've added not only a physical cost of the mailing, I've got all the processes as well as all the potential of error as I move through that process. So you're very right with framing it in that fashion. But I think there are some things that I can evaluate without actually doing it yet. So thank you, sir, for that.
Thank you. Professor Smith, you have the last 30 seconds before we close.
Yes, I would add that we actually do have some evidence. It's anecdotal at this point because these are elections that are happening at the local level. In Alachua County, where I live, our supervisor during local elections would have her drop box open 24/7, starting from the day that vote by mail ballots went out. So that if I got mailed my vote by mail ballot 3 weeks before, I could stop by and drop it off on my way to work. Under SB 90, because she has to have continuous monitoring by staff, which she puts into having 2 people there because she's facing herself a $50,000 fine if one of those people goes and takes a bathroom break while that box is open. She, quite rightly, reduced it down to 2 days, the same 2 days of early voting at the supervisor's office on a Friday and a Saturday before that local election. That's akin to having an ATM outside of your local bank that is only open during banking hours, and it has to have a security guard outside it. What's the point of having an ATM if you have to have it limited in those days and times and have a security when, in fact, we routinely deposit money without concern about it going to somewhere else. So that's a real concern. The other thing that has happened is we had a higher rate than ever of rejected vote by mail ballots in our January runoff special election in the city of Gainesville. 10,000 or so out of 150,000 registered voters voted. This is fairly typical for local elections. It's the super of the super of the super voters. And yet we had rejection rates because vote by mail ballots came in late. They came in late because the drop boxes, which people used in the general election, were no longer there. They thought that they would get there on a Thursday and put it in the mail by a Tuesday election. They were rejected because they came in late. We also had cases such as my wife who wanted to request a vote by mail ballot. My wife, she registered her vote when she moved to Florida in 2001. She used her driver's license. That driver's license is no longer the driver's license she has. And yet she's been able to request a vote by mail ballot and vote properly before SB 90. She had to then put in her driver's license number. It didn't work because it's not the same driver's license that she did when she registered to vote. She tried to put in her last four of her social security number. She didn't register with her last four of her social security number. So that didn't work. And she didn't have the time to update her registration and then request a vote by mail ballot in that process. So it is having real world effects. We just don't know how extensive right now because these are one-off local elections that we've been seeing since the implementation of SB 90 in July of 2021.
Well, I hope she didn't take
Thank
advantage
you
of
very
early
much.
voting or voting on election day.
She voted on election day.
No harm done.
I'm going to go ahead and we're 5 minutes after. Thank you for indulging those extra few minutes. I think it was important, but I want to say that in addition to thanking you all for your comments, if you joined to provide public comment today, but we didn't get a chance to hear your remarks during the briefing, please email your remarks to Liliana Schiller at lschiller@usccr.gov within 30 days of today's briefing, which would be April 27th, 2022. This information is also available on the final slide in today's presentation. I would like to thank all of our speakers and members of the committee and members of the public for attending to share testimony with the committee today. We very much appreciate your time and we'll keep your comments in mind as we draft our report. Information on upcoming meetings will be available in the Federal Register. I will now adjourn today's briefing. Thank you all.
Thank you, Nadine.
Take care.
Thank you.